The biggest question, especially after what we saw yesterday, his first day in court, is this. This is a man who is not only the Nairobi governor, but currently allegedly being looked into for about 357 million Kenyan shillings. And the fact that he also has about 19 other charges. The criminal records have also resurfaced again of Mike Sonko. But here's the thing. We see your fellow senators and members of parliament coming out to defend him as his defense legal team. This aspect, how do you relate with this? What are your thoughts on this? The fact that we have members of parliament, legislators, your fellow senators out defending the governor.
Thank you very much and good morning. What I would say from the beginning, it is unfortunate that the security agencies did mandate Governor Mike Sonko. I think elected leaders with that stature, sometimes it doesn't, this machismo and gizmo that these people are doing to arrest leaders is not good at all. They should just have issued summonses, and I don't think Governor Sonko would have avoided. And we have seen the argument that he might have been roughed up and injured. Secondly, you have asked, before I answer that, is that I've seen some people trying, especially the media, bringing the criminal record, and even during the application of this bail and bond, that Governor Sonko has a criminal record. You know, there is a principle of double jeopardy. If a case has been handled at some point, you can't even arise in another different set of matter.
Yes. So
that matter is a weak line of argument by the defense. I know the bail conditions and terms might be quite stringent, considering many factors. For example, in the issue of flight risk, it might be demanded that he deposited the passport with the court so that he can't travel outside the country.
What about this serious issue of conflict, where your fellow senators and members of parliament...
Yeah, I'm coming to that. I'm coming to that. Secondly, because what is important is that the issue that is before the court of law is not an aspect of Public Accounts Committee, CPAC, in the Senate. And I don't think there is any conflict of interest, because as the oversight that has been provided for under Article 96, there is no direct conflict. In fact, the courts, Senator Orengo had been challenged before, and that matter has been put to rest. He has represented even Governor Sospita Ojamong in some of the cases. I don't know why Senator Mutula Kilonzo Jr. and Senator Murkomen, it becomes so unique that many people, and this has been done before, that decision has been made before, so there is no direct conflict. Because on the aspect of 357 million, we are not aware, because when a governor comes before the Senate, there are audit queries. Those audit queries are being flagged by the Auditor General. Those are the queries that will be now questioned by the Public Accounts Committee. So you see nothing wrong with Senate defending Mike Sonko, the issue of any ethnic and leadership? You're not questioning that? No, I don't see, because these senators are advocates of the High Court, and they are the officer of the court. But Senator, at the end of the day, who are we fooling? Because at the end, they are legislators. Tomorrow, they're the ones who will be making laws. We are the same people who come and sit here and we discuss national issues on how to fight corruption and this war when it comes to fighting graft. But here we are again. Who are we fooling? No, it's not about fooling anybody, but I can tell you, if they were sitting on the bench to make key decisions of either conviction or acquitting, you would have raised that on the issue of conflict of interest. But these are just submissions that will be made to a court. For example, tomorrow in the ruling of bail and bond application, it will be in the discretion of the magistrate, Douglas Ogoti. If they were sitting as part of the bench, you would have said that the senators might be influenced in making that decision. But in my own opinion,
the direction you are going to.
Thank you. I was coming to you, the issue.
What you are driving at is assuming that they end up impeaching Governor Sonko. That impeachment at the Assembly is not final. The matter still has to go to the Senate, and you have particular senators who have come out in defense of Governor Sonko in a court of law. Does that amount to double standards? That is the direction that you take.
Can I assist my friend?
Definitely.
For you, it's a double standard?
It is definitely.
You know, impeachment process is a political process. It's not a legal process. So you should distinct. So it is not legal. It is anywhere. Even when you look at the Trump's impeachment hearing, that's a political process. It's not a legal process.
So Senator, what happens to personal conviction, knowing that you're a senator, a legislator, standing to defend someone who allegedly is still innocent, but also
now you are treading in a very dangerous ground, because there is a principle and doctrine of presumption of innocence until proven guilty.
So how do you
But it looks, you know now you are behaving like DPP, who is you are guilty until proven innocent.
No problem. How do you answer to Kenyans who are asking personal conviction, ethics, leadership? Where does that come into?
This is somebody, for example, just like a doctor. If you are a doctor and you are operating on a patient, despite that you might be a father or a bishop or a legislator, the way we have Nyikal, Professor Nyikal, that one does not in any way prevent you from becoming the professional lawyer. And I've told you that matter has been settled before, because you remember Senator Orengo at one point, he represented some of the clients and people were asking, is he a state officer or not? That is why we are saying, why is it suspicious? Why is it when it comes to Sonko and when it comes to Senator Murkomen and Senator Mutula Kilonzo Jr., everybody is raising this Ula Balu and Obris, yet when other senators have represented, let me not be specific about Orengo, because when other senators have represented other governors, it does not become an issue.
Senator, let's deal with the matter that is at hand. And obviously you see Senator Mutula, Senator Murkomen, Member of Parliament Dan Manzo, they are in court supposedly on the side of the defense, that is of Mike Sonko. Explain to me how you separate yourself from you, the advocate, versus you, the senator, who is supposed to be oversighting the counties.
I have told you, and as an advocate of the High Court, you are an officer of the court. So you have an honorable duty and fidelity to the law. That is why even as leaders, we are sworn as per the Constitution. The fact that these senators and even Dan Manso, the legislator, are representing Governor Sonko in court does not in any way bring an issue of conflict of interest, because I have insisted those matters we are not aware, because we will now, when the Auditor General will flag out audit queries, it will come to the Senate Public Accounts Committee. So if Governor Sonko appears in future, we are not certain that the same question will arise. And you know, it will not arise, you know why? Because there is sub judice rule. So it will not arise, because the same matter will not arise in another forum.
Let's take a look at this. Let's take a look at this, Senator. Yes. So understandably, Governor Sonko is a client of these three advocates of the High Court, correct?
There are 12.
I'm talking about those who are in
Parliament.
Okay. So they're his clients.
Yes.
And then the client comes to the Senate and they have to oversight how he's managing the county of Nairobi. You don't feel any conflict of interest that would come out of there? And what is the extent of an impact in as far as their role is concerned? But
when we are sworn into office, even myself and Gerard, we normally say, without fear or contradiction of anything, as provided when we are sworn in. So the aspect is Kenyans can judge when Governor Sonko is appearing before the Senate and some of these issues, audit queries are being raised. If there is a procedure, there is a process, there is a way that it can be seen when they're answering audit queries. Because if you're asking a question maybe about ECD centers in Nairobi, and you are saying there are ECD centers, and there is always a documentation. So it is not about something of word of mouth between a senator and a governor. There is a process, there is a documentation. That report will come to the Senate. When PAC finishes the report and the findings, they always table the report before the Senate of the counties. And that is when we debate either to adopt or reject it. So at the end of the day, I don't see, and I want to assure Kenyans, there is no direct conflict of interest when senators or members of parliament represent their clients.
Okay,
even if the president or deputy president is charged, the members of National Assembly can still represent them.
Okay, I want to take a quote here, and Senator Murkomen is quoted as saying that what you are seeing is a coordinated assault on the counties and their governments. He said yesterday, adding that he got involved in the case in line with Article 96 of the Constitution, which mandates the Senate to protect counties. I mean, why would you have to do that in a court of law, where yet you can do it at the Senate chambers?
Well, the determination made by a committee of parliament sitting would many a times give recommendations. And part of the recommendations that we commonly prefer is asking the DCI or EACC to take up a matter in cases where we have detected an anomaly in transactions. Because our major role is to protect the interest of the Kenyan people in line with Article 1 of our Constitution. And once that has occurred, then the work of members of parliament would end at that point. But if you allow me, I would want to step back a bit and really look in depth into this matter of members of parliament representing a person whose role also cross-cutting with the role of a member of parliament. It is true that Governor Sonko has appeared before parliamentary committee, or PIC and PSC of the Senate, and I want to believe that the report is not out yet. Maybe he will be called again to shed more light on certain transgressions at City Hall. But, you know, the mere fact that members of parliament who are professional lawyers would appear in a court of law. And, you know, Sonko did not lack lawyers. He has 12 of them. I really do not know additional merit from 3 who are members of parliament who could have actually just allowed other lawyers to take up the matter, because these are issues about perception. The mere fact that members of parliament have come out in defense, and we are not saying that that does not fall under their purview, under their jurisdiction. Yes, they are lawyers of a court of law, and they have you know, the latitude to represent their clients. But the mere fact that there is a shred of double interest, you know, that perception itself ought to have allowed them to just let other lawyers take a leading role in this. Because you ask yourself, what would be the recommendation from the Senate, therefore, having looked at the audit report from the Auditor General on very serious transgressions from City Hall? So the mere fact that you have these lawyers here is a testament that, you know, at that point, he can easily be cleared. It is about perception. And you know, some of these lawyers, let me finish this. Some of these lawyers, I want to believe, but I'm not belittling my lawyer friend here, are soliciting for work and are using it for political expediency. And it is quite absurd, therefore, looking at what is being captured on the screen, that this is taking the connotation of Tanga-Tanga, that Tanga-Tanga is regrouping to defend one of their own, and that does not portend well.
Seeing it?
No, I mean, you can see.
And speaking of that is
a weak. I didn't expect from my neighbor and my friend that argument, because Sonko is a leader of Team Wanjiku. He's not in Kieleweke.
Is he still on?
Yeah, he's still on, because he has I've never seen him in Kieleweke or either Tanga-Tanga. So my friend is just he's just tying up issues that are not there. But I think the substantive issue is that in as much as he's arguing on the basis of perception, any process, even I've told you, impeachment process is a political process. When it even comes, if Nairobi City County Assembly members impeach Governor Sonko, for example, and it comes to the Senate, the fact that it will come to the Senate, there are procedures that have been provided by the Constitution on how the impeachment should happen. And myself, there is an impeachment procedure bill that is lying in the National Assembly. The people who have become an obstacle in realizing the dreams of devolution in this country are members of National Assembly. The reason we have chaos, because we had provided an amendment on assumption of office, county government, assumption of a governor's office, by which is lying in National Assembly at mediation state, the amendment to county government, providing the breadth to the ruling by the Supreme Court on how to replace the county government. These are some of the legislations that we would, the National Assembly should have put in place to facilitate if such scenarios arise in case of the issue of this. And that is why the ruling, we sought the ruling. And in fact, this issue, I don't know why people are bringing issue of conflict of interest. The substantive matter is what happens in Nairobi City County. And that is why the Senate Deputy Speaker, Professor Kithure Kindiki, made a ruling last week on what happens if, for example, Governor Waititu and Governor Lon Kolal and Governor Sonko possibility when this justice. By the way, I want to tell my brother, as a lawyer, the decision by Justice Muvenguki is a bad law. It is by incurium. In fact, it has set as
to be successfully appealed.
Yeah, that's what I mean, my own opinion, because you can critique the decisions that have been made by the court. But what you are saying is that that is a bad law, because the provision provided for under Article 179, 180, 181, the power to elect a governor should remain with the people. And the power to vacate the office of the governor is highlighted or set out by the Constitution.
Not that you go there, Senator.
One does not include a court order
Senator,
to remove somebody from office.
Not that you go there. The argument of Justice Mumbi Ngugi was that you cannot have someone who is overseeing the operations of a county and is accused of embezzling the same funds, and then you take him back to go and oversee them, despite the fact that there's a presumption of innocence. In fact, what would you rather see? That someone is accused of stealing from the coffers that he manages? What would you want to see?
I want to agree with you, but the fact that, you know, we need the proper interpretation, and I saw Director of Public Prosecution, which of course nowadays I don't call him a Director of Public Prosecution, I call him Director of Political Prosecution, misinterpreting the decision and the ruling.
But you know, the actual position is Director of
Yeah, but you know, when you have conflict of interest in some of these matter, it shocks. So what the interpretation is, there is a difference between absence of a governor and vacancy in the office of the governor. I agree that governors should be barred from accessing the office because it becomes a sin of crime. But that one does not take the functions of a governor. It means he might not show up on the gazetted physical office, but that one does not prevent a governor from executing their functions from any part of the county. That is why in case of an absence of a governor... What would
those functions include? Because if it's...
Can I finish briefly?
You will.
When there is absence of a governor, the law is not clear, but the power is given to the governor to delegate some of the functions to the deputy governor. But if there is vacancy of the governor, then the deputy governor now can assume into the office, like we have seen in Nyeri, to carry on the executive functions of a governor. So we should distinguish between the vacancy in the office of the governor and the absence of the office of the governor, and the governor being barred from accessing the office because it has been declared a crime scene.
Senator, still on this issue for perception.
And mention something before I forget. You know, senators show this degree of partiality already on conduct of a governor by so appearing before a court of law to defend such governors. Now, the eventual decision or the eventual picture is that once that matter goes before them, it will be curtailed. We have seen, tell me, any governor whose impeachment motion has passed in the Assembly and consequently passed in the Senate. Now, this kind of partiality is what we are talking about. The first line of oversight of governors is at the Assembly. And when members of our county assembly have come out to impeach a whole governor, then there must be very clear transgressions.
And Honorable Jared, let me just pick it up from there, my next question. The perception and the fact that we still haven't seen any governor who had a court in case being persecuted. You look at the defense team, and it's still connected with what the senator said. The DPP, if you look at the defense team for Sonko and that of the prosecution team, Sonko has 12 lawyers. 12. Exactly. So is the DPP, is judiciary, are we serious about this issue of fighting corruption after DPP does its investigations? Here we are in court. Sonko has 12 lawyers. As a prosecution team, they only have 2.
So actually, you know, you're very right to say so. They're also playing, you know, for the public gallery. What they are doing firstly, and the lawyers that are representing Sonko are not lawyers of mean feet. These are lawyers of high caliber. And you look at the DPP bringing 2 guys who are never known by anybody. I mean, we were seeing them for the first time in a court of law yesterday. And you have a battery of lawyers.
So what is the place of that? Is it just intimidation?
Well, definitely. Well, it is basically, you know, to intimidate Ogoti, that, you know, these 2 people cannot circumvent the argument of 12 people.
Can DPP not...
Can I correct something so that it is not... By the way, you know, this country is very interesting.
And you have seen DPP crying foul.
The presumption of innocence. And my friend Jared, who I respect so much, is making as if the governor that has been accused or somebody who is in court is already guilty.
No,
if at the end of the day is cleared of those charges, Sonko will have to have his day in court, and that is why we normally say, and that is why there is also doctrine on principle of separation of powers.
But what if he is convicted?
What about the parliament? What about the role that the judiciary plays and the executive? So the doctrine of separation of powers, and therefore there is no day parliament can order judiciary order parliament or the executive. So in as much as we are arguing on the basis the fight against corruption, ensuring there is prudent use of resources in counties, we should not forget that we should allow the law to take its course by ensuring that anybody who is accused, there is a presumption of innocence until proven guilt.
That's not in doubt, Senator, but as we exit from this conversation, there's still something I need to clarify from you.
Yes. Because
you said that Justice Mubingi Ngugi's ruling was a bad law, but she said that she was referring to a provision that would indicate that elected officials are not supposed to step aside, and she said that the provision violates the letter and spirit of the Constitution, Chapter 6 on leadership and integrity, citing that in releasing a governor in a criminal case, conditions must be imposed that protect the public interest. And therefore the question, so should you say that even if a governor is to be barred from office, they can just move away from the scene of crime and execute their mandate from a different location? How does that protect the public interest, and specifically on resources allocated to a county steered of that are being supervised by the chief executive officer, who is the governor?
In fact, I can give you the citation of that case. It is criminal case revision number 25 of 2019, Moses Kasaine Lolkolal versus DPP 2019. And in fact, he made remarks as opita dictum. It was not part of the judgment. Those were just remarks, and the place of the dictum is known by the legal scholars. What I can say, in my own opinion, and that is why when a judgment is passed, that's why I've said it's bad law. It is not good, because it is like when you are issuing a court order, it is like you now, that person is no longer the governor, therefore you want the deputy governor to become the governor, which is not provided for under Article 180, 181, and 179 on the grounds, just let me conclude, on how to remove a governor to create a vacancy. The fact that there is a court order not to access an office because it has become a crime scene does not, and I want to insist this, does not take away the executive function of the governor, or does not create a vacancy in the office of the governor.
It does not.
It creates only absence, and therefore in the absence of the governor, if there is an absence of the governor, the only way that the deputy governor can exercise the functions of a governor is when governor, through writing, is given. And when you look under Article 135...
Senator,
my brother is speaking.
Allow me to take a short break, because he's refusing to answer that question, but you still have to. We take a short break.
Can I do just a second?
No, which question? And I've told you, court order is not part of electing.
Senator, we need to take a break. You can text us on 22422 or tweet us at Citizen TV Kenya, at Sam Gituku, at Zinzi_K. The hashtag to use is daybreak.